Hey everyone, Harry here to talk about Michael Cohen's last stand to try to get justice for conduct that a federal court already has found was a pretty flagrant constitutional violation of his First Amendment rights. Okay, let me set up the violation. So, it is galling and ironic to him, without doubt. But recall, he testifies in Congress first and blows the whistle on Trump's practice and Trump Organization's practice of misvaluing either high or low, depending on whether they were trying to get insurance or pay taxes or get loans, their properties. The very practice that leads to the civil case that Letitia James has brought against Trump. He basically phonies up documents, and in the Letitia James case, he got loans at more favorable rates than he should have, given what he was really putting on the line as collateral, and sometimes just complete bogus lies, most notoriously taking a 10,000 square foot apartment and just calling it 30,000 square feet. Anyway, so Cohen testifies to this, and his testimony, he serves as the basis for the AG civil lawsuit. But the SDNY considers it and doesn't bring criminal charges against Trump. Now, this is for conduct before Trump was president, so it probably isn't precluded by the OLC memo saying you can't indict a president. Possibly the SDNY is deterred by the higher-ups in DOJ, as Cohen believes, who put the lien on then U.S. Attorney Berman. But for whatever reason, Trump is not charged, but Cohen is. The whistleblower himself finds himself under indictment and convicted in a plea for his role in this fraud, and he goes to jail. And COVID then comes, and he's back in home confinement, but he is writing a book that is critical of Trump and eventually comes out. And in his story, accepted by a federal court, there's a meeting with him and counsel and officials from the Bureau of Prisons, and they say to him, okay, pal, we'll let you go. But here's a piece of paper that we want you to sign. And the paper, as he observes it, is not a normal form. It's just been kind of put together for this very case, and, you know, a very odd document. But it basically says that he will stand down and not write his unfavorable volume about Trump. And they say to him, you do this, you can walk. If you don't, we're putting you back in prison. And there's some suggestion, more than suggestion, allegation by Cohen that they even say, we're going to indict your wife on they really play hardball. He doesn't do it. He doesn't sign the paper, and they put him back in jail, in fact, in solitary confinement. And on that basis, he moves for his freedom under habeas corpus, and a federal district court judge releases him, finding that this was done to him in retaliation for his exercise of his First Amendment rights. Okay? So we have a finding that Cohen has bitterly alleged and now is vindicated that they did this because he was going to write an unfavorable book about Trump, and that's just, you know, totally illegit to do. But now what? Because we now come to the legal part of the case, sort of the second big point to make, which is when a federal official violates your constitutional rights, there is you can use it perhaps in the defense of the criminal allegations itself. Cohen did just that and got his freedom as a result. But now he wants redress, he wants compensation for the constitutional violation. And to do that, you need to sue a person under what's called a Bivens action. And that is the statute, the very important civil rights statute, 42 U.S.C. 1983. But it is brought as a so-called, even though that's the statute, Bivens claim. And Bivens is the name of a U.S. Supreme Court case that recognized the ability of aggrieved citizens to sue officials. In that case, it was Bivens versus 6 unnamed FBI agents, for purposeful violation of their constitutional rights and to get money, to get redress. But the court, this was at the sort of high water mark of the progressive Warren Court. I think it's an opinion by Justice Brennan. It recognizes this Bivens action, but in the last 15 years or so, as conservatives have taken the reins of the court, they've never overruled Bivens, but they've time and time again said, that's not a Bivens remedy. This isn't a Bivens remedy. No, I don't think that counts for a Bivens remedy. And they've said only in the, quote, most unusual circumstances is a Bivens remedy appropriate, as opposed to, for example, using the constitutional violation as a defense in the criminal case, which he could do, did do, but it's different from the actual civil case here. And the court has said that only in the most unusual circumstances, and guess what? They have yet to find those circumstances. So the actual legal issue here for Cohen is, can he maintain a Bivens action? And under Supreme Court precedent, is this the most unusual of circumstances that in theory would permit it, even though in practice the Supreme Court anyway, hasn't seen a Bivens case that it's green lit in over 10 years. So the argument now is in the Supreme Court, where he's saying to the Supreme Court, please take this case and find that I have a valid Bivens remedy. And to do that, he is arguing this is most unusual, right? What do you need, Supreme Court? A finding by a district court that a federal prison official violated First Amendment rights in this way. How more unusual and rank can you get? Recognize the Bivens claim and let me go forward with it. And that we are in the Supreme Court. There doesn't seem to be a good reason why they wouldn't. And yet all the betting odds would be that they won't, because they just don't. And they're not going to start now. One school of thought might be, if it's a dead letter, why don't you just put everyone out of their misery and overrule it? But the court doesn't want to do that yet, at least when it was decided. It seemed a pretty important kind of component of citizens' remedies and weapons against the state when the state purposely violates its constitutional rights. So it's out there in theory, but maybe dead in practice, and Cohen's case is the test of it. So we are right now, just to be clear, he's petitioning for a writ of certiorari. He's saying, Supreme Court, please take this case. So they can deny taking it. That wouldn't create any precedent. They can just say, no, we won't, and the law will remain. Bivens is okay. In theory, but good luck trying to find the case that actually fits it. And I think that would be what most people would expect, but what Cohen is asking is take this damn case and show that Bivens isn't dead and there are unusual circumstances, and at the very least recognize that my case might be that and remand for a district court to determine it under, whatever guidance you would give. So that's Michael Cohen's last stand, trying to petition for review in the Supreme Court. If they turn him down, he's kind of out of luck, as are basically everyone who's tried to do a Bivens claim in the last many years. It seems to be alive in theory, but dead in practice. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.